another video. I was just checking my phone to see everything and what was going on, stuff like that. Okay, let me get on YouTube. Okay, let me just load it up. Cause I got all the other ones loaded up. It was just that one. They not loaded up. It's just on the YouTube app. I'm gonna watch this video right here. I think I wanted to watch it yesterday, but I opted not to. This is YNW Melly's judge and I state motion to reconsider. I don't even know what state motion is. What is that? I'm pretty sure
Switch to Shopify and sell smarter at every stage of your business. Take full control of your brand with your own custom.
Comes with developed that there's an institutional bias, prejudice, and demands in this case.
Thank me later.
The YNW Melly murder trial had an intense motion hearing today. They discussed motions that involve throwing out the state attorney's office from the case. Melly's lawyer says that the state attorney's office want to win at all costs, even if it means lying because the case is high profile. They're quoted saying the state attorney's office has an institutional bias and prejudice towards Melly that demands for this case to be dismissed. The judge also responds to the motion to suppress situation where the state asked him to reconsider everything in my last video, and you're going to see what happens with that. A lot's going on in this video. The audio is terrible. I took a shower halfway through. Sorry. Hit subscribe. Here we go. All right, so we got defendant's response to state's motion for rehearing, reconsideration, and clarification right here. Defendant files this response in opposition to and request to deny the state's motion for rehearing, reconsideration, blah, blah, blah. However, nothing in here should be considered as the defendant waiving any future appellate rights or even agreeing with all the court's rulings. The defendant filed 13 motions to suppress and believes that each one should have been granted in totality and that all evidence seized under search warrant should have been suppressed. Okay. The state says before the trial court considers the merits of a Fourth Amendment motion to suppress, the defendant must first establish a factual basis justifying his or her claim to have possessed Fourth Amendment right at the time of the alleged invasion. A more recent case would have required the state to have raised and preserved the issue of standing at the time of the motion to suppress, not 9 days after this court ruled. The defendant notes that the state relies on no Florida cases or even 11th Circuit cases to limitation of scope from service. Rather, the state apparently wishes that it was in Colorado or Kansas, as it heavily relies upon 10th Circuit federal law. Melly's team is trolling these boys right here. The state never raised the issue of independent source prior to their motion for rehearing. It is not mentioned in their omnibus response to the motion to suppress, nor was it raised at the time of the hearings. It was abandoned by the state as they produced no testimony or evidence that any information that they received from any of the search warrants they executed had been gained through an independent source. The state argues inevitably discovery and independent source as if they are one concept. They are closely related but are different concepts of law. Alright, for the motion to suppress on the iCloud, let's see what Melly's team has to say about what the state said. So remember, this is a response from Melly's team to the state saying that the court got it all wrong. A lot's going on here. The state again raises the standing issue. They wrote, because the defendant was not forthcoming or whether or not he was still proceeding with the strategy of claiming the film was not his, the state proceeded with the argument as if he had standing at the time. However, standing was addressed in the initial response filed by the state and briefly addressed during the argument on November 21st. The state later indicates it raised the issue of standing. If the defense was not forthcoming whether or not he was still proceeding with the strategy with claiming the film was not his, then why would the state proceed with the argument as if he did have standing? This is such a clusterfuck, dude. The state is acknowledging they have waived the issue of standing, proceeding on as if the defendant did have standing.
Mobile games are going big with Google Play Games. Battle it out with...
I mean, this is like almost riddles, bro. Now they're quoting the state right here saying, standing was addressed in the initial response filed by the state and briefly addressed during the argument. It is not a correct recitation of the record. Standing was not addressed as to the phone in this motion and the state's omnibus response. The state never contested standing in this matter, as it was way more than obvious that the defendant did and does have standing. The defendant introduced the affidavit for search warrant, which was sworn to and admitted into evidence without any objection. In the affidavit, Moretti states the following. This detective is requesting a warrant pertaining to the data stored with the Apple iCloud phone number. The phone belongs to Jamal Demons in this case. This affidavit alone acknowledges that it is his phone, his iCloud account, and that it is known to others to be his phone and iCloud account. If standing was an issue, Mr. Demons has standing. Alright, so here's a dumbed down sentence for you guys. The state's position seems to be simply, from service providers, we get so much information that it becomes so time consuming and tedious. Fourth Amendment protection should go by the wayside. Law enforcement's time is more important than the citizens' rights, and who wants to burden the service provider? Pretty good point from Melly's lawyers right there. The state suffers from knowing too much. That is, they have have 4 years of investigation behind them. They interject their opinions and facts that were not known at the time of the writing of the search warrant affidavits and signing of the search warrant. The state goes through a litany of justifications in need of the items that this court suppressed, possibly if the contentions were made in the affidavit for search warrant and referenced therein. There must have been probable cause and a nexus. However, the state's after the fact 4 years later recitation of why they need the evidence is improper and not legal justification. The state has put together arguments that, had they been contained in the affidavits, may have led to probable cause, nexus, and even an expansion of this court's ruling. However, they are not contained in the affidavit and they are not a part of the court's review. They were not testified by Moretti at the hearings, therefore they are not based in evidentiary fact. The state said it is common knowledge that defendants claim a device is not theirs or that it is a community phone used by many. The identity of the account device user at the time of the homicide must be proven. In order to prove that identity behind the keyboard, the state must authenticate that device as the defendant's. In order to do so, the pattern of life must be shown, which requires going beyond the mere 6 hours permitted by the court's order. Now we're talking about the time frame of the 6 hours from 3 a.m. to 9 a.m. And now this is what Melly's team says about that. Whether this is common knowledge or not is up to debate. This justification to expand the 6 hour time frame that the court limited was inappropriate as it is not contained in the affidavit. It goes on to argue in other orders by the court, and the time frame is 30 to 45 days. They then argue that the same time period should at least pertain to this motion and court order. They fail to realize that each motion was independent to itself. They fail to realize that each affidavit is independent to itself. They fail to realize that the probable cause in each affidavit is independent of itself. They fail to realize that a 30 to 45 day time period may or may not be appropriate in some situations dealing with search warrants. However, what this court did as far as time frames and other warrants had no bearing, is independent of, and has no relevance to what the court ordered in this motion to suppress. So the state comparing each motion's time frame to each other is wrong because apparently they're all independent. Withers, in a recorded statement, says he was communicating with Melly on Snapchat. Okay, if standing was an issue, which is not, the affidavit alone confers standing upon Mr. Damons. In the state standing section for Snapchat account, there's a more perplexing and irrelevant statement. So right here, they're pointing out that Melly's team constantly objected to Miss Bradley in the first trial, saying that Melly's phone was Melly's phone on the screen or in front of the jury. Somehow the state wants a negative inference that requiring the state to do what they are required to do at trial has a bearing on standing. In this section, the state once again contends that only the 4 corners of the affidavit should have been looked at by this court. They also fail to explain how they could argue inevitable discovery and independent source without testimony. Rather, the state seems to be under the belief that no testimony should have been allowed, but their representations within their motion for rehearing should alleviate the need for testimony and evidence. The state's position seems to be that they can't put on witnesses to establish inevitable discovery or independent source because that would be outside the 4 corners of the affidavit. However, they apparently believe that this testimony should be supplemented by the state after the hearing is over and after the court is ruled with factual allegations and arguments that are not part of the record. Now, talking about the nexus, proving the user of the account and relationship context. The problem with the state's motion for rehearing is that it is a mixture of legal argument, facts from the affidavit, facts.
Bro, I'm pretty sure all they're saying is just, pretty much, that he's not getting out anytime soon. Is all I'm hearing. But, thank you for watching. This is a long video, bro. I wasn't expecting all this. We out of here.